Honorable the Speaker.
Thank you, Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Miscellaneous Provisions Pensions Bill 2019 listed in Appendix 2 be now considered.
Honourable members, the question is that the Senate amendments in the Miscellaneous Provisions Pensions Bill 2019 listed in Appendix 2 be now considered. All in favour say aye.
Aye.
Any against? The ayes have it.
Clause 2, in paragraph B, A, delete the words following subsection and substitute the words following subsections. B, delete the words subsection and substitute the words subsection. And C, insert after subsection 2 the following subsection. 3, notwithstanding subsection 1, a person referred to in that subsection who ceased to hold office before 25th January 2019 June 2019 is entitled to the revised retiring allowance referred to in that subsection as of 25th June 2019 and thereafter on every 5th anniversary referred to in that subsection.
Attorney General.
Speaker, may I ask if there is agreement for us to do all three clauses? It would perhaps be in best interest if we could, subject to the will of the House. If so, the clerk would read the other two.
Whip. You can't read and nod.
Yes.
Yes.
No, you can't say yes, sitting, please, sir.
Yes, Madam Speaker.
Clerk, therefore you can read all.
Clause 3, in paragraph B, A, delete the words following subsection and substitute the words following subsections. B, delete the word subsection and substitute the word subsection. And C, insert after subsection 2 the following subsection. 3, notwithstanding subsection 1, a person referred to in that subsection who ceased to hold office before 25th June 2019 is entitled to the revised pension referred to in that subsection as of 25th June 2019 and thereafter on every 5th anniversary referred to in that subsection. Clause 4, in paragraph B, A, delete the words following subsection and substitute the words following subsections. B, delete the word subsection and substitute the words subsection. And C, insert after subsection 2 the following subsection. 3, notwithstanding subsection 1, a person referred to in that subsection who ceased to hold office before 25th June 2019 is entitled to the revised pension referred to in that subsection as of 25th June 2019 and thereafter on every 5th anniversary referred to in that subsection.
Attorney General.
Thank you very much, and I thank the whip for the agreement of the House. Madam President, Madam Speaker, forgive me. The proposed amendments to clauses 2, 3, and 4, agreed to by the Senate, all relate to the same intent and purpose. Act number 13 of 2019, which is the Act of Parliament which created an...
Just for us on clarification for the procedure, Ms. AG, can I refer you? I think you have the procedure, so you have to beg to move before you begin the presentation. It should be on page 1 at the bottom. Yes?
For your guidance, the last time I did that, I was preempted from speaking.
Go to page 1.
Yes,
The
ma'am?
bottom of page 1.
Much obliged. Madam Speaker, I beg to move that this House agree with the Senate amendments to clauses 2, 3, and 4, as read by the clerk. And I thank you for your guidance, Madam Speaker, in the Miscellaneous Provisions Pensions Bill 2019. Madam Speaker, in Act number 13 of 2019, assented to by Her Excellency the President on the 25th of June 2019, certain material provisions were brought into effect, specifically the improved pension arrangements for retiring allowances at Section 6B of the Retiring Allowances Legislative Service Act, Chapter 203. Secondly, at Section 4A of the Prime Minister's Pensions Act, Chapter 251. And thirdly, at Section 11A of the Judges' Salaries and Pensions Act, Chapter 602. In the course of those particular provisions, those amendments made by Act number 13 of 2019, it became necessary to, out of an abundance of caution, include a particular provision which specifically provided for a clarification. Let me state that, a clarification and not a correction of Parliament's intention. Certainly, Madam Speaker, under the rule of Pepper, Inspector of Taxes versus Hart and related appeals, it is a case coming from the House of Lords, 1993, 1 All England Reports at page 42. The classic provisions as to statutory interpretation and the use of Hansard as an aid for interpretation were laid out. It became incumbent upon inquiries being made of the government as to whether the assent and operationality of that law, Act number 13 of 2019, whether that law allowed for the activation of provisions which I will basically call back pay to come into effect. The Minister of Finance in piloting Act number 13 of 2019 was pellucidly clear in stating Parliament's intention, in stating the government's intention in bringing this law pursuant to Section 53 of the Constitution, that we were not engaging in anything other than a prospective application of the law, so that the improved benefits for pension, which included a housing benefit, that they would only come alive prospectively, but that retired persons in the 3 categories, Prime Minister, Legislator, and Judges, would be entitled on a go-forward basis on 5-year anniversary cycles from the date of their retirement. Madam Speaker, a second issue arose, and that second issue was whether the time in the prospective application of the law was such that even though the law came into effect on the 25th of June 2019, that one would have to wait several years before the law of prospectivity kicked in. In other words then, would someone who had retired 4 years previously and who qualified pursuant to Act number 13 of 2019 have to wait 1 year after the proclamation, after the assent of the law? And if someone who had retired 1 year prior to June 25th, 2019 would have to wait 4 years hence. It therefore became prudent, Madam Speaker, apart from the amendments which were caused in this House and which were accepted by the Senate, to actually add in a further qualification. And it is that qualification that finds itself on the supplemental order paper in respect of clauses 2, 3, and 4. I might add, Madam Speaker, you will notice that this does not apply to the office of the President of the Republic, because that law is clear in and of itself. In the round, Madam Speaker, the rationale for the insertion of the subclause 3 to each of these provisions, that is in clause 2, clause 3, and clause 4, this is intended specifically to clarify the law. The clarification of law in putting forward is based upon allowing the persons who will prospectively be entitled to improved benefits to take avail of those things as at the date of assent of the law, which is the 25th of June 2019. That therefore harmonizes and resets the pension clock to that particular date so that all persons, particularly those in the category of retired judges and retired legislators, and in those two pots themselves where we have public knowledge of extreme difficulty, that the beneficiaries can take avail of those improved arrangements. I'd like to underscore that persons in these two categories are entirely different from persons in the general public service category, largely because this is a contributing pension arrangement where 6% of emoluments are paid into the pensionable aspects. And therefore, even though they are an entirely smaller pool of persons, it is to be materially distinguished that these persons are in a contributing pension arrangement. I'd like to state that the government looked very carefully at any issues of constitutionality, in particular, whether there was a vested right that Parliament would be disturbing if we were to pass this law. We had a robust discussion in the Senate over it. Indeed, one of the views expressed was that we should specifically speak to whether the Constitution itself in sections 133 to 136 could be disturbed. Those sections of the Constitution, 133 to 36, apply to effectively the principle that you cannot derogate from the terms and conditions of sitting judges. I'd like to add in particular on this occasion that we are very comfortable that we're not disturbing the constitutional arrangements against non-derogation, because this is not the category of sitting judges. We're dealing specifically with retired persons, and in the case of judges, we're dealing with the Judges' Salaries and Pensions Act, Chapter 602, and that act is the act which treats with retirees. So there is a distinguishable position between the constitutional arrangements of sections 133 to 136 and Chapter 602, which deals with the retirement benefits. As a subset of that, this House can find comfort in the fact that the principles against retrospectivity also apply here. They confirm the narrow compass of prospectivity. They actually also confirm that we are well within the parameters of Bennion in terms of 6th edition language that has been offered as to when something is retrospective. We are clearly not in a retrospective situation, and we are also ably assisted by two important decisions. The first is in the case of Maxwell, and the second in the case of Wainwright. In those two particular judgments, we also find comfort that this law was not in any circumstance to be considered, nor can it be considered as being retroactive, such as to engage in vested rights, which would otherwise require, if being disturbed, a constitutional majority. These are the reasons for the proposed amendments, Madam Speaker, and unless I can be of any further assistance, I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to clauses 2, 3, and 4 of the Miscellaneous Provisions Pension Bill 2019. Member for Garani Central.
Thank you very much. Thank you very much, Madam Speaker. I'll be quite brief on this. The Attorney General mentioned two words: retrospectivity, and he referred to the public service in his presentation. And we understand that these amendments are meant to place limitations and also to start the process on a specific date, June the 25th, 2019. But I want to indicate that notwithstanding the fact that it addresses this issue of retrospectivity, the legislation to which this clause is now, these three clauses are now inserted, have forever opened the Pandora's box of pensions as a feature of negotiation, and the issue of indexation as a feature of future negotiations. And I alert and I warn the government of this. The public service, of course, is not affected by this, and it's not meant to, and it's for a very specific purpose. But it's the public service that's likely to respond to this. Our position on the bill is well known, and I will not articulate it here. And we took a certain position for very specific reasons. And so I acknowledge what the AG has said, but as I indicated last time, I thought that that was the last act of incompetence in the management of this bill. I'm afraid to say that this one is the last act, because I don't know what is going to come again. Now, it is no major thing, I understand, but all of this is caused by the fact that the legislation was hastily conceived, and the attempt was made to rush it through the parliamentary process. The end result is that we end up with these several amendments, minor though they are, these several amendments which really, with a little care and attention and time, could have been properly done in the first instance. Thank you very much, Madam Speaker.
Attorney General.
Madam Speaker, thank the honourable member for keeping to his word to being brief. I'm compelled to match, but also importantly to correct the record on a few matters. Madam Speaker, the honourable member has asked about the issue of retrospectivity. I'd like to add that one of the underpinning requirements to prove that one is within the proper zones of constitutionality with respect to an allegation of retrospectivity was set out in the case of Northern Construction. It is in that particular case in the High Court, Court of Appeal, and very importantly in the Privy Council, that the Privy Council was invited to consider the issue of retrospectivity as it related to the greatest betrayal to the people of Trinidad and Tobago in the proclamation of Section 34. The Privy Council, in dealing with the issue of retrospectivity, as it applies in this bill, the Privy Council...
I think if my ears are not betraying me, I believe the Attorney General is responding to the word retrospectivity, which I believe was in his presentation, which I believe were the two starting opening words of the member for Caroni Central. Attorney General.
Thank you. So the case that we're treating with on retrospectivity, the locus classicus, the case of highest record in our land, comes from the Privy Council. And in that Privy Council decision, in assuring this Parliament that these amendments are in form, Madam Speaker, the Privy Council, in examining the greatest betrayal of a cabinet to the country of Trinidad and Tobago in the hasty, inexplicable proclamation of Section 34, the Privy Council said that you must act with alacrity in coming to the Parliament and that you must move to get that process right. And in that process, the Privy Council looked at the position of the need for certain amendments. And so that we find an answer to what the member for Caroni Central has said. Caroni Central said that, the honourable member said that he hoped that this was the last act of incompetence because he thought that these were minor amendments that could have been done at the same time. If that were the case, then I need only point to the Privy Council decision in the Northern Construction case, which pointed out to the need for certain amendments to that law to repeal Section 34, and had it not been for the Minister of Finance, then sitting as member opposite in the opposition bench for Diego Martin Northeast, to guide then Attorney General on the choice of attorneys.
Correct is right.
Lord Panic as choice of attorneys, and the choice of wording which I as a senator sat in those days and brought amendments. God help us all, the Almighty, in his wisdom, that had it not been for those several amendments, we would never have seen that incompetence and betrayal to the people of Trinidad and Tobago cured. So the precedent that we rely on today to speak to the issue of retrospectivity is anchored in the Northern Construction case. The need for tweaks to amendments have been brought quickly. This matter was laid on the 7th. We dealt with it in quick fashion immediately upon assent, and we certainly found ourselves moving in the right direction. The honourable member went further, Madam Speaker, in the context of saying notwithstanding retrospectivity, to raise the issue that indexation and pensions would certainly be a context for discussion of future collective agreements in the public services. And just very quickly on that, I think that that is a form of intellectual crocodile tearing. And I'll say why. It is crocodile tearing for pensioners to say today that there should be a discussion when the honourable member sitting as the Minister of Planning did absolutely nothing to ensure that the decline in pension entitlements in this country caused by an aging population with negative growth rates and contributions which hold up the pensionable arrangements, the honourable member himself did absolutely nothing. No public advocacy, no charge to then Prime Minister Kamla Persad-Bissessar, nothing. So this government will accept no crocodile tears on the pretense that there is a benefit to be looked at for public servants in this country, particularly when the honourable member and the cabinet led by Siparia had the option to consider indexing, to consider contributions to pensionable arrangements similar to that which legislators deal now. So, Madam Speaker, I think that this is intellectual fraud at its highest, Madam Speaker, at its highest. And you know, Madam Speaker, I have a great sense of pity to people who actually look to what is being said, you know. Sincere tones, straight faces, and an attempt to be with an intellectual aplomb. But it is nothing other than a glorious deceit, Madam Speaker. When you get to the details of the structures, it is a glorious deceit. Something which Naparima seems to enjoy, chuckling and laughing all the way through this contribution in his crosstalk. I pity people, Madam Speaker, if that is what they have to rely on with Naparima. Madam Speaker, I think I'm coming quickly to an end here, where the honourable member spoke lastly about the need for positioning on the issue of indexing and positions. I can tell you that the current Minister of Planning, the current Minister of Finance in this government are looking assiduously at the reports that come out from the actuarial considerations of arrangements to this effect. And had we been in a position where we did not suffer from a 96% drop in revenue, from the consequences of waste, corruption, and mismanagement, from the consequences of members opposite having no regard for the kleptocracy that prevailed in Trinidad and Tobago in the period 2010 to 2015.
48-4.
Attorney General, please continue.
Yes, Madam Speaker.
The man is enumerate,
Had
illiterate,
the honourable members opposite
ignorant,
been not living the high life in the United Nations, sipping champagne at the taxpayers' costs, sipping champagne and being chauffeur-driven, Madam Speaker.
48-1.
Continue.
Madam Speaker, champagne sippers and chauffeur-driven people seem to have a little bit of thin skin when the truth is revealed, Madam Speaker. So, Madam Speaker, I think sometimes the old Shakespearean adage or maxim or reflection that thou doth protest too much comes to light, Madam Speaker. Madam Speaker, champagne sippers and chauffeur-driven people who forget their roots and bases, who forget to look after pensionable people, to look after indexing issues based upon the back of proper actuarial sciences, to deal with the concept of aging populations, declining growth rates, birth rates, Madam Speaker. These are people to watch with a cocky eye and to take no advice from. Madam Speaker, these amendments are proportionate, they are constitutional. I thank every member of the independent bench who supported this. The members of the opposition refused to support these arrangements, but I'll end by saying, same members who catching us in the corridors to tell us, boy, thanks for fixing us up.
Tell you.
Please go ahead and accelerate my gratuity.
Every one of them.
Every single
In
one of them.
writing, they want
Put it in writing.
48-6, not every single one of them.
You know, member for Naparima, you're always given an opportunity to join a debate. An opportunity which sometimes you don't take. Well, even before, right? And I remind you, sometimes, you know, as I say, maybe we still accustomed of environments or fora where we sit and we talk across the table. All right? But please, Attorney General.
Thank you, Madam Speaker. Let me repeat what I was saying. Every member opposite, everyone entitled to gratuity,
Yes, no time here.
rush the Minister of Finance, the member for Diego Martin Northeast, to say, take my written consent to accelerate the payment of my gratuity.
Which
But
I did.
Madam Speaker, which the Minister of Finance did.
Munilal get paid for.
All members said,
Munilal get
as
paid before
Orobuchis
me.
was
He
paid
get paid
before the
before
Minister of
me,
Finance,
before me.
all members said, thank you for bringing this legislation.
get paid first.
And I want to say
Get paid first.
why it is you have to watch Naparima with a very careful view. The Honourable Member stands up in trying to raise a standing order which was dealt with, pretending almost that he is entitled to a pension under the retired legislator's position, never having served a 5 years as a minister or 5 years in the diplomacy aspects where he would otherwise be entitled, knowing fully well that he's not entitled to stand up and pretend I didn't accept it. Well, how are you accepting it if you weren't entitled? Madam Speaker, sometimes the ghosts that haunt people come to the surface, you know. Sometimes they occupy places that they should not be. Madam Speaker, I will say my prayers for my friend from Naparima and for the people from Naparima who have to suffer under that form of representation. Madam Speaker, I thank you for the opportunity to correct the misinformation offered by the opposition, and I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 2, 3, and 4 of the Miscellaneous Provisions Pensions Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Madam Speaker, I beg to move that the House do now adjourn to a date to be fixed.
Honourable members, the question is that this House do now adjourn to a date to be fixed. All in favor say aye. Aye. Any against? Did I hear against? Okay, so members, we're not yet on recess. Okay, please be reminded, we're not yet on recess. The ayes have it. In accordance, this House do now stand adjourned to a date to be fixed.